Hope amidst uncertainty. Partner visas for unlawful non-citizens in Australia. It is a common question whether individuals without a valid visa can apply for a partner visa in Australia. The answer is yes, it can be possible. This is specifically for those in a genuine relationship with an Australian citizen, permanent resident, or eligible New Zealand citizen. The pathway is the onshore partner visa, subclasses 820 and 801. However, this process is very complex. It has many legal requirements. Being an unlawful non-citizen adds extra difficulties. Careful attention to detail is absolutely essential for any chance of success in these situations. It offers a ray of hope for many. The onshore partner visa allows an applicant to remain in Australia while their application is processed. This is a significant advantage. It means couples are not forced to separate for long periods. The subclass 820 is the temporary partner visa. If granted, it allows the holder to live, work and study in Australia. After a certain period, usually 2 years from the application date, the applicant may be assessed for the permanent subclass 801 visa. This permanent visa provides long-term residence. This system acknowledges the importance of keeping families together. The journey to this outcome requires patience. Australian immigration law, while firm, does provide avenues for individuals in genuine relationships. There are humanitarian considerations built into the systems. The government recognizes that life circumstances can be unpredictable. Sometimes people find themselves unlawful through no fault of their own, or due to difficult situations. The partner visa provisions reflect an understanding of the emotional and social importance of committed relationships. The welfare of any children involved in the relationship is also a very significant factor that is carefully considered by the department. This demonstrates a balanced approach to immigration control. However, it is crucial to understand that this pathway is not straightforward. For an unlawful non-citizen, the application process is much harder. There are additional legal hurdles to overcome. These are known as Schedule 3 criteria. These criteria must be satisfied, or compelling reasons must exist for them to be waived. Navigating these complex rules requires a deep understanding of immigration law. Many applicants find this overwhelming. Therefore, seeking professional legal advice is not just recommended, it is often vital for a successful application. This ensures all aspects are correctly addressed. Understanding unlawful status and the support offered by BMS Global. Becoming an unlawful non-citizen in Australia can happen in several ways. The most common way is by overstaying a visa. Many people enter Australia on a valid temporary visa. This could be a student visa, a visitor visa, or a temporary work visa. All these visas have an expiry date. If a person remains in Australia after this date without obtaining another visa, they become unlawful. Sometimes visa holders might misunderstand the conditions of their visa, or they might simply forget the expiry date. Personal circumstances can also make it difficult to leave or apply for a new visa in time. Another way a person can become unlawful is through visa cancellation. The Dept of Home Affairs has the power to cancel visas. This can occur if a visa holder breaches their visa conditions, for example, a student not attending classes or a tourist working illegally. Providing false or misleading information in a visa application can also lead to cancellation. While less common for partner visa applicants who are already onshore, some individuals may have entered Australia without a valid visa in the first place. Each of these situations creates a complex legal status. This status must be addressed carefully. This is where organizations like BMS Global can provide essential assistance. BMS Global is a migration consultancy firm. They have expertise in Australian immigration law and policy. Their team has significant experience in handling complex visa applications. This includes partner visa applications for individuals who are unlawful non-citizens. They understand the specific challenges these applicants face. They are equipped to provide tailored advice and support. Their focus is on helping clients navigate the intricate requirements of the Australian migration system. They aim to achieve positive outcomes for their clients. BMS Global plays a crucial role in guiding applicants through this difficult journey. They begin by assessing an individual's eligibility for a partner visa. They explain the stringent legal criteria, including the demanding Schedule 3 requirements for unlawful applicants. BMS Global assists in meticulously gathering all necessary documents and evidence. They help to prepare a comprehensive and persuasive application. Their knowledge of current immigration policies and procedures is invaluable. By managing the complexities, they can significantly enhance the prospects of a successful visa grant. They provide support from the initial consultation to the final decision. The Onshore Partner Visa Application, a step-by-step guide. For an unlawful non-citizen, the first step before lodging a partner visa application is often to regularize their status. This usually means applying for a bridging visa E, BVE, also known as subclass 050. A BVE allows an unlawful non-citizen to remain lawfully in Australia while they make arrangements to depart, or while another visa application, such as a partner visa, is being processed. It is a critical interim measure. Without a BVE, an unlawful non-citizen is at risk of being detained and removed from Australia. Securing a BVE provides a lawful basis to stay. The application for a bridging visa E is a separate process. It must be lodged with the Dept of Home Affairs. To be granted a BVE, an applicant generally needs to demonstrate that they're taking steps to resolve their immigration status. For those intending to apply for a partner visa, showing evidence of this intention is important. This might include proof of a genuine relationship and preparations for the partner visa submission. BMS Global can assist with BVE applications. They ensure that this crucial step is handled correctly. This helps to provide stability while the more substantial partner visa application is prepared. Once the BVE is in place, or concurrently, the main partner visa, subclass 800 and 2800 firsts, application can be lodged. The core requirement is to prove a genuine and continuing relationship with an Australian partner. This involves providing extensive evidence across various aspects. These aspects include the financial interdependence of the couple. They also include the nature of their household, social recognition of the relationship, and their commitment to each other. Additionally, all applicants must meet health and character requirements. This often involves medical examinations and police clearance certificates from countries where they have lived. Gathering the required documents and lodging the partner visa application is a detailed and often lengthy task. Evidence of the relationship can take many forms. Examples include joint bank account statements, bills in both names, and rental agreements. Photographs of the couple together over time are useful. Statutory declarations from friends and family who can attest to the genuineness of the relationship are also vital. The application itself is lodged online through the Dept of Home Affairs IMI account portal. All information provided must be accurate, complete, and truthful. Any omissions or errors can lead to significant delays or even visa refusal. Overcoming hurdles challenges appeals and the need for expertise. A significant challenge for unlawful non-citizens applying for a partner visa onshore is meeting Schedule 3 criteria. These criteria are part of Australian migration regulations. They apply to most visa applicants who are unlawful or hold certain bridging visas at the time of application. Schedule 3 requires that compelling reasons exist for the visa to be granted despite the applicant's unlawful status or visa history. If these compelling reasons are not accepted by the department, the partner visa cannot be granted. This is a major hurdle. Understanding and addressing Schedule 3 is absolutely critical. Compelling and compassionate reasons are not defined exhaustively in law. They are assessed on a case-by-case basis. Factors that may be considered include the length and nature of the relationship. The best interests of any Australian citizen, children of the relationship, are a primary consideration. The extent of hardship the Australian partner or children might suffer if the applicant were forced to leave Australia is also important. The circumstances that led to the applicant becoming unlawful may also be taken into account. Presenting these reasons effectively requires careful articulation and strong supporting evidence. This often necessitates skilled legal argument. Despite the best efforts and preparation, partner visa applications can sometimes be refused. If the Dept of Home Affairs refuses the visa, there are usually options for review. The most common pathway is an appeal to the Administrative Appeals Tribunal, AAT. The AAT conducts a merits review of the department's decision. This means the AAT will re-examine all the facts and evidence. They will decide if the correct decision was made according to the law. The appeal process can be lengthy, often taking many months or even years. This period can be extremely stressful and uncertain for the couple involved. Given the complexities, the high stakes, and the potential challenges, seeking professional assistance is paramount. Navigating the Australian partner visa system is difficult for any applicant. It is significantly more challenging for those who are unlawful non-citizens. Immigration law is intricate and subject to frequent changes. Mistakes in an application can have severe and lasting consequences, including refusal and exclusion from Australia. Registered migration agents or immigration lawyers, such as the team at BMS Global, provide invaluable expertise. They understand the system thoroughly. They can help prepare the strongest possible case, maximizing the chances of a successful outcome.